Hi, everyone. Thank you for joining us for our pop-up Canadian Citizenship webinar. Today, we are joined by our panelists, Hilete Stein and Claire MacLean, who will be discussing eligibility for Canadian citizenship for those with a Canadian-born grandparent. Please feel free to ask any questions via the questions icon at the top of your screen. We will do our best to address them at the end. If the panelists do not get to your question, you can contact them through the information provided on the screen. With that being said, I will hand things over to Hilete and Claire.
Thank you so much. So thank you everybody for joining us today. We're going to be discussing today the most recent update in Canadian citizenship law, which impacts a group of people who have been facing a long-standing issue in Canada. And this group of people is known as lost Canadians. So who's a lost Canadian? A lost Canadian refers to individuals who were born outside of Canada to a Canadian parent that was also born outside of Canada. And this group of people has been affected by a rule in Section 33A of the Citizenship Act, which prevented them from automatically inheriting Canadian citizenship from their Canadian parent, essentially cutting off the second generation born abroad from obtaining citizenship by descent. So before we jump in, let's just kind of take a step back and look at, what are the two main ways that we can acquire Canadian citizenship. So the first way is probably the most familiar route, which is called naturalization. And that's when a permanent resident of Canada applies to be granted citizenship by showing that they meet various eligibility criteria, including, physical time spent in Canada, knowledge of Canada, language requirements, etc. And then there's another group that can obtain Canadian citizenship by descent. And these are certain descendants of Canadian citizens can apply for proof of Canadian citizenship. And that means that this is a right that is basically vested to them at birth by virtue of specific rules in the Citizenship Act. So, for example, if I am born in Canada and I have a child that is born outside of Canada, I pass my Canadian citizenship on to my child, even though they were not born here. Okay. So what is the second generation cutoff that we've all been hearing about? That is when if my child who was born outside of Canada and got their citizenship through me has their own child who is also born outside of Canada under the second generation cutoff rule, which we have in Section 3.3 of the Citizenship Act, their child who's the second generation born abroad cannot acquire Canadian citizenship automatically at birth. And this rule was introduced in 2009, and it precluded the second generation Canadians who were not already citizens at that time from applying for proof of their citizenship status. But because this rule was putting many people in limbo, it was challenged at the Ontario Superior Court of Justice about, I guess we're at a year and a half ago now. And I'm going to let Claire take you through what happened in that challenge, which got us to where we are today.
Yeah, so that was a really interesting case before the Ontario Superior Court of Justice. It's called, I believe you pronounce it Borkvist. But anyhow, in that case, it was basically ruled that the second generation cutoff rule was unconstitutional as it violated Section 15 equality rights in the Canadian Charter of Rights and Freedoms. In making that declaration, the court issued a 6-month temporary suspension of the provision becoming invalid in order to give the government time to pass legislation that would remedy the unconstitutionality. So I think we're having some trouble with the audio. Hopefully you can all hear me. As a result of the court's decision, the government passed what was called Bill C-71. It was an act to amend the Citizenship Act, and that was tabled in May of 2004. It was proposed as basically a solution to remedy this unconstitutionality by introducing a forward-looking substantial connection test for certain second-generation Canadians to acquire citizenship by descent. That substantial connection test only was proposed to apply to people who were born after the bill entered into force. For those who were born before the bill was passed, there was no substantial connection requirement proposed, and basically just meant that the second generation limitation would not apply to second or subsequent generations. So this bill was pretty highly contested in Parliament. And because of that, it couldn't be passed before Parliament prorogued earlier this year. And when the prorogation took effect, it died at the second reading before the Senate. So that means the bill is no longer before the House. And while all of this was going on in Parliament, there were multiple extensions of time that were granted by the court to Borkvist's suspension on the declaration of invalidity. And that was to preserve, the importance and integrity of Canadian citizenship by not just having a gap in the legislation. So it was March, I guess, just about a month ago, March 2025, before Parliament resumed at the end of the month, that a 12-month extension of time was sought to that declaration of invalidity in order to allow the government to pass new legislation to remedy the unconstitutionality. And on March 13th, the judge temporarily suspended the deadline, which was previously March 19th, until April 25th of 2025. And on or before April 25th, we're not exactly sure when this will happen, but the court will review whether immigration has implemented a viable interim solution to mitigate the hardship that second-generation Canadians who are waiting for this legislation to be passed are experiencing in the interim. Okay. So on the same day that the court made that order, immigration actually did announce an interim measure for certain second-generation Canadians to apply for Canadian citizenship. And it is basically designed to allow these groups of people to apply for what's called a discretionary grant of citizenship and to prioritize citizenship applications for kids who were born or adopted after December 19th, which is the date that the decision was handed down in Borkvist, if their Canadian parent had a substantial connection to Canada. And the substantial connection in this case is defined as that Canadian parent having at least 3 years, 10,095 days of physical presence in Canada before their child was adopted or born.
1,095.
1,095, right. So these discretionary cases, they really were previously only used in very unique scenarios. So where someone had significantly contributed to Canada and wanted to apply for citizenship, or someone was experiencing significant hardship. But now you'll see these four groups of individuals have basically been authorized to apply under this interim policy. So people who were born before December 19th, 2023, who are subject to the first generation limit, so those second generation Canadians. The second group we talked about, so people who have kind of been born in the interim where their parents do have that substantial connection of 1,095 days. A small group of individuals born prior to April 1st, 1949, who basically had lost Canadian citizenship by operation of law and it wasn't subsequently restored. And then another kind of niche group of individuals who had also lost their Canadian citizenship under a former requirement that would require these people to apply to retain their citizenship. And that law was actually repealed in 2009. So this fourth point really only applies to people who were born outside of Canada between 1977 and 1981. So the most common cases we're seeing, to be quite honest, are for the traditional definition of second generation Canadians, which is outlined at point 1.
Right. And we've been getting a lot of calls on these over the last few weeks in our office, because it's been, this interim measure was announced, but then it was a little bit unclear in terms of, how do you apply? How do you actually submit an application under these new interim measures? And we've seen sort of the website updated multiple times over the last couple of weeks, including right up until yesterday, I believe. So the process is in flux, and what we are seeing right now is that for these individuals who are affected, the process involves submitting an application for a citizenship certificate by submitting a traditional proof of citizenship application under Section 3 of the Citizenship Act. However, the form and document requirements under these interim measures are the same as effectively what you would be submitting if you were the first generation born abroad and applying for your proof of citizenship. So some elements of the application form in terms of questions or documents that are required, you may not be able to meet if you're applying under these interim measures, and those should just really be addressed in a cover letter that accompanies the application. So you're submitting the proof application, and then once the application has been submitted, IRCC will get back to you, sending you a letter that basically is going to confirm that the first generation limit is still technically in effect, but inviting you to submit an application for a grant of citizenship under Section 5.4, which is the discretionary grant provision under which these interim measures are being implemented. So one key thing to note in terms of the difference between a proof application and a grant application. So the proof application is basically applying, saying that you would like to get citizenship vested to you by birth. Okay, so effectively, as of the date of your birth, you were a Canadian citizen and are asking for a citizenship certificate to be recognized as such. A grant application would give you citizenship as of the date the citizenship is actually granted, not necessarily as of the date of your birth. So under these interim measures, we're sort of putting these two processes together, whereas step one would be applying for your proof of citizenship. And then when IRCC comes back to you advising that the first generation limit is still in effect, at that point, they would invite you to apply for the grant of citizenship and withdraw the proof application. And the grant of citizenship under Section 5.4 would likely include additional evidence, additional application forms, government fees, and what is sort of yet to be seen is whether applicants will be required to meet other elements that we would typically see in a grant application. So, for example, typically when you're applying for a grant of citizenship, if you're between the ages of 18 and 54, you would be required to write a citizenship test. We don't know whether applicants applying under these interim measures will be invited to do a citizenship test as well. Okay, so that's the general process. And if you require a citizenship certificate urgently, so effectively faster than the normal processing time, which right now is about 3 to 4 months, or 6 to 8 months for minors that are living outside of Canada or the US, then you can apply for urgent processing if you need to get your citizenship for any of the urgent reasons outlined on our slide here. So what are the urgent reasons? So immigration is looking at, are you applying to help avoid a situation of potential harm or hardship due to factors such as race, religion, nationality, sexual orientation, gender identity or expression, or membership in particular groups? We've had a lot of inquiries over the last few weeks from LGBTQ trans individuals who are experiencing discrimination or worried about harm in their country of origin. So that would be, for example, an urgent reason that you may want to apply for citizenship. we have at sort of the bottom 2 points. So if you have applied for a job and you would like to get your citizenship urgently in order to come to Canada and begin work in Canada, that may be another factor to request urgent processing. If you've applied to school and you've been, accepted to a program here and want to come study, as a Canadian citizen rather than as an international student, that may be a reason to request urgent processing. So there's a lot of flexibility in terms of the reasons that one may apply for urgent processing. Important to note, if you're requesting urgent processing, there's no guarantee that IRCC will process the application urgently. But if you do fall under one of these potential reasons, then you would put in your request for urgent processing with an explanation letter, any supporting documents for your urgency request. So, plane ticket, a letter from the employer or the school that you want to attend, a doctor's note, etc. And, hopefully IRCC will prioritize your application. In terms of next steps, so as Claire mentioned, on April 25th, the Ontario Superior Court is set to review the extension that was granted to determine whether, the full 12 months that IRCC requested will be granted. And there's different potential outcomes. So, one outcome that we may see is that the interim measures get extended further in their current form. Another outcome may be that the interim measures are extended but become, more restrictive, maybe to resemble some of what we saw proposed in Bill C-71 in terms of substantial connection test. Or maybe the court does not grant the extension, at which point the declaration of invalidity would stand and the second generation limit would no longer exist. So lots of potentials, coming up this month. As Claire mentioned, we don't necessarily know whether what the outcome will be, and whether it will extend all the way until April 25th. So when clients are calling us, asking, should I apply or should I wait to see what happens? We recommend that, if you do qualify now under the interim measures, get your application in as quickly as you can.
Yeah, and kind of what's to come in the future is a little bit unknown at this point. I mean, we did have Bill C-71, which was introduced when the Liberals were in power, are in power still. Canada is holding a federal election at the end of April, and we expect that the results of that election will quite significantly influence what happens in the future. So either government will need to pass this legislation, this declaration, the suspended declaration of invalidity is temporary. And I mean, if we do see a change in government, the Conservatives really did oppose certain provisions within Bill C-71. It allowed kind of unlimited generations of individuals to automatically become Canadian citizens just by operation of law. There was some concerns about the number of individuals that would extend Canadian citizenship to, and that number was, quite a bit larger than I think had initially been proposed. So that was one point of contention. The other one was, there was, a lack of criminal record checks, whereas if you apply for a grant of Canadian citizenship, your background is reviewed to a certain extent. This kind of automatic vesting of Canadian citizenship rights that C-71 would have put into play wouldn't have had those same checks and balances. So there's quite a few unknowns at this point, but the clock is ticking, and we do think that once the election happens, this hopefully will be a matter of priority, because the previous extensions granted by the court were not happy with the delay. Obviously, recognizing this is a very important matter, they were granted, but hopefully we'll see some new legislation tabled very soon after the election.
Yeah. So I do see some questions coming in through the question box, and we'll try and get through as many of those as we can. So one of the questions I'm seeing here is, does the citizenship status of the parent impact citizenship eligibility of the grandchild of a Canadian citizen? In other words, if the parent never claimed citizenship but is eligible to do so, can the grandchild still claim citizenship? The answer to that is yes. If the parent was eligible for citizenship by descent as the first generation born abroad, they were a citizen at birth, even if they did not obtain proof of that citizenship. So in the application, you would effectively have to demonstrate the lineage through, birth certificates, and basically going down to the second generation born abroad.
I think that actually answers quite a few of the questions.
Yeah,
Here's one. Does a Canadian-born great-grandparent make someone eligible for citizenship? When the legislation passes, if it passes similarly to how it was drafted in Bill C-71, yes, this doesn't just extend to the second generation, it extends beyond. Now, the interim measures that we went through today do appear to only apply to the second generation. So it kind of remains to be seen how a link to Canada through a great-grandparent will impact your rights once the legislation passes.
Looking through questions to see if there's any others. Okay, so this is one we're actually seeing a lot of as well. A father was born in 1918 in rural Quebec. They do not have a birth certificate and suspect there never was one. What can be done? It was likely a birth at home situation. So we're getting a lot of these questions, and sometimes you can access birth records through the provincial archives. And there is a process to apply, which varies across different provinces, to try and access these records. If nothing is found in the records, but you do have other documentation that indicates that the birth was in Canada, so things like baptismal records, hospital records, if they were born in a hospital, marriage certificates, death certificates, whatever you have that would indicate a place of birth in Canada, I would recommend collecting that and including it as part of your application, because ultimately these applications are under Section 5.4, which is a discretionary grant provision, meaning that IRCC does have discretion to look at what you do have and determine whether, based on those documents, you meet the criteria. So even if you don't meet the specific, strict requirements on a document checklist of having that birth certificate, if you do have other documentation that tends to demonstrate where your grandparent was born, I would recommend including that.
I think we have time for a few more questions. And here's like one that just came through. If the Conservatives do come into power, will they potentially appeal the Ontario court's ruling? They have indicated that they are supportive of the Superior Court's ruling. They were not supportive of how the bill was drafted. So I do not think they can, nor are they likely to try and appeal that decision. Specifically, the appeal period has passed. But they are supportive of this. They will likely, well, they could put in a little bit more of a restrictive test to narrow the groups of individuals beyond the first generation who are eligible to apply for proof of their Canadian citizenship.
That's one of the reasons we're recommending that everybody try and get their applications in as quickly as possible. Whether these applications will be decided prior to April 25th is unlikely. So, it is also possible that, when you do put your application in, and you get that letter back from IRCC, there may be a request for some additional documents or information, or additional requirement requests.
And I think a lot of the questions, these cases are very heavily driven by the facts and your personal circumstances. They are drafted to apply broadly. But, our recommendations and specific eligibilities are always going to apply based on your personal circumstances. So if you do have questions, how should I specifically do this? Is my specific case eligible? Please do reach out to Hilete and I. Our emails are on the slides, and we're happy to answer questions about eligibility. Share the information we do know about the process. And it is a process that's, as Hilete mentioned, it was updated as recently as yesterday. So it's a good time to be having these conversations.
It's certainly evolving. So, okay. Well, thank you, everybody. And if we didn't get to your questions, please feel free to reach out to us. And we are happy to help in any way that we can.